So, what is a provisional patent and how does it work? I moved to do this one today because I was talking to a very smart man a very smart creative inventor, who mentioned that he filed a provisional patent application, and his expectation was that in a year he would find out whether the government cleared it, whether it was approved by the government, and at that point he would have patent rights. So that is not what it does. That's not how it works. And in fact, that's not how any patent works. Patent application process is it's a longer. I mean, you can actually do it in a year. Perhaps there's a fast track, so it's possible. But it's never just gets filed and then just goes through and gets cleared. That's not what it is. You should expect some pushback. I've got other videos on that. But this one, because of that expectation, I thought it was important to do this. It seems no matter how many times I share with people that a provisional is not, it will never be a patent, it will never give you enforceable rights for your invention. It is a disclosure document. And no matter how many times I say that, it doesn't stick. And maybe there's other information on the internet that's wrong that gives people the impression that it becomes a patent. So here's a couple myths and truths. So number one, provisional patent application, that even is misleading because it never becomes a patent. But what it does is it fixes your priority date. That fixes in the trademark office. We're talking about the United States. It basically timestamps and date stamps your application, which discloses your invention. Except that it doesn't really disclose it publicly because provisionals are never published. I tell people to think of it as you're disclosing your application, your invention, and you're putting it in a vault that's timestamped. And then the U.S. Patent and Trademark Office, they're keeping that record of it for you. And if you do nothing within a year of that filing date, it will just quietly expire. It never gets published. It never gets reviewed by the patent office. It just quietly expires. So that's now hopefully, perhaps if you file it. So there's a couple things. When you file it, you are officially patent pending. So you can go around. That's kind of the purpose of it. You can go around after you filed it, and you can pitch your idea. I always recommend also continuing to use NDAs, non-disclosure agreements, during that period. It's kind of like belt and suspenders. If you want to be extra safe, then use both of those things. So you're patent pending, you can mark it patent pending, and that is actually a true statement if your provisional is still in force. But again, when I say in force, it just means that you're allowed to say patent pending. There's nothing to enforce with a provisional. Then what ideally, so you're out there, you're pitching your idea, you're finding your people that can help you make it, you're trying to get it launched, getting your prototypes made. It gives you that year where you can do that and still hold on to that priority date. And then sometime within that year, no later than the 1 year after you file, you then can file a non-provisional application if you have decided, based on where you are at that point, that it makes sense to continue trying to get a patent. So if you, during that year, find out that it's not feasible to make it, or you change your mind or whatever, then you can just walk away. And again, your invention is not disclosed. It's still in the vault. It just quietly expires. Okay, so if you want to continue getting a patent, continue to being able to say patent pending, you need to file a non-provisional. Technically, you could probably file another provisional and it would still be patent pending. But really, if you ever want to get a patent, you have to file a non-provisional and if you want the benefit of that early priority, your provisional priority date. And remember, priority is what determines prior art. That's the significance of it. So depending on your filing date, anything before that is prior art to you, but anything after that, you are prior art to it. So that's the importance of it. That's first come, first served. So again, in order to get a patent, you have to file your non-provisional sometime within that year if you want the benefit of that priority date of the provisional. And that's what a provisional patent application is. Again, no enforceable rights. It doesn't get approved by the government. It is a disclosure document that protects your filing date and your prior art date so that you have a better chance of getting a patent, and you have the freedom to say patent pending and share it with the people that you need to share it with during that 1 year exploration and development phase. I hope that was helpful. Catherine Cavella, IP Works Law.